So the Mississippi law said that a narcotic drug or marijuana was a narcotic drug according to the district attorney there, or state's attorney, and that a narcotic drug was anything that had the addiction sustaining qualities of heroin, opium, codeine, etc., or anything that the State Board of Pharmacy, upon investigation, found to have those addiction sustaining qualities. And since the state had no State Board of Pharmacy, that didn't apply. The first one didn't apply because there weren't addictive sustaining qualities. Or the third way that you could be classified, or a drug could be classified as a narcotic drug and therefore illegal, was anything that was defined as a narcotic under the federal narcotics laws. Well, this was problematic in Mississippi. Mississippi had been bitching for a number of years about integration orders of the court and various other, what they called infringement upon the state's rights by the federal government. So I went down there and filed a motion to dismiss, and at a press conference I stated that I thought it was very disingenuous and hypocritical of the state of Mississippi to claim that there was all kinds of federal encroachment on states' rights by the federal government, when the most primary of the states' rights is the ability to define a crime, which they delegated to the federal government. Well, I won that case, which was interesting because it was a states' right case, and I used the states' rights defense against the state of Mississippi, and the courts there bought the argument. But they bought it because there was a hardcore belief that the states had a certain degree of sovereignty. And one of the greatest of the sovereign rights was the right to define a crime. So we had all kinds of problems. Criminologists wrestled over these problems for years and years and years. For instance, take the crime of theft. Well, in some states, the difference between petty theft and grand theft was $50. Other states, it was $100. Some states, it was $500. So you could steal a $100 item in some states and it would be a misdemeanor. And you could steal a $100 item in other states and it would be a felony. And there's a big difference in the way these classifications were treated. So there was a push to have uniformity in the law, and it was agreed upon in principle, but the carrying it out was very difficult. Another thing that occurred back then was the idea of basic rights, inalienable rights, or whatever the press at that time wished to call them. And the idea behind rights was that there were certain rights that should be guaranteed every citizen under the due process of law cause, and the states shouldn't violate those. So, for instance, Illinois would give a third degree to an arrestee, the third degree meaning they'd interrogate him and intimidate him and keep at it for as long as they could until a lawyer showed up or until somebody told them to stop. Well, a friend of mine back then was called in on a case for a client of his named Danny Escobedo. And Danny Escobedo was arrested by the Chicago police, and the family called the lawyer, who was at the police station when they brought Danny in and took him to the interrogation room. and they sweat or beat a confession out of Danny. And it went to trial. And there wasn't much of a trial because Escobedo had confessed. Well, my friend appealed the case to the Illinois Supreme Court, and there it went to the U.S. Supreme Court, and it became the famous case of Escobedo versus Illinois. And it said that at that point, when the finger of suspicion focused on a person, or become a suspect, in other words, that he was entitled to a lawyer, and you were supposed to advise him that he could get a lawyer. And in the Escobedo case, it was very obvious because the lawyer was sitting right there waiting to see him, and they interrogated him without it. A little while later, another friend of mine from Phoenix, John Flynn was his name, had a case involving a guy named Miranda. And that case went to the U.S. Supreme Court, and that's where in that case, they said you had to advise the defendant that he had these rights. You just couldn't assume that he had the rights and that he should assert them, particularly if he had no idea that he had those rights. So you get the Miranda advisement, and you get the Escobedo ruling about search and seizure. And local cops were raising holy hell about that because they were used to slapping defendants around, and they viewed their job as just getting convictions rather than following the law themselves. So there was sort of a tradition, and the further south you went, the stronger the tradition was that the ends justified the means as far as criminal law enforcement was concerned. And the main battleground of that was what they called suppression of evidence, Fourth and Fifth Amendment motions. And the suppression law was that if something were taken from a defendant in violation of the requirement for a search warrant or a confession, that you couldn't use that in court. Now, there was a whole bunch of lazy-ass prosecutors who said that that wasn't the case in England under common law, and we were therefore inventing law, and it wasn't conservative, we didn't follow precedent, and it was judge-made law and all this other propaganda bullshit, which isn't the case, because these people have never studied common law as such, and they didn't know any better, including a U.S. State Supreme Court here in Colorado, Supreme Court judge that was known to be some sort of legal expert. The fact of the matter is that in England, in the English colonies, there wasn't a motion to suppress evidence. What happened is you filed a separate lawsuit asking for what they called a writ of replevin, and if the item was illegally seized or taken, then the plaintiff, the guy from whom the stuff was taken, was granted the possession again, and therefore it couldn't be used at any criminal proceeding. Now, when the United States decided to make all of the procedures subject to rules, published rules, rather than common law, then they had what they called motions practice, and you had a motion to suppress evidence, and that motion took the place of a writ of replevin. But a lot of numbnuts out there that don't know the difference. And anyway, there was this big battle going on, and the big proponent of applying certain individual rights to the states as guaranteed under the federal Constitution was Earl Warren. Now, Earl Warren was a Republican appointee by Eisenhower, and they thought he was going to be a nice conservative judge. The problem was he was too conservative because he believed in the common law and followed the common law and believed in the democratic or common law form of government rather than modified states' rights, more heavy-handed government. So rather than adapt Marshall's views, the right wing in this country started this big protest to impeach Earl Warren because he was trying to impose judge-made law on the states against their will, contrary to the states' rights guaranteed in the 9th and 10th Amendments. So this war was going on for quite a while under the Truman and mainly under the Eisenhower administration, and not too many people bothered to look it up and to track the history and the fact that it was from the common law of England that items illegally gained or illegally taken or obtained by illegal searches or seizures shouldn't be used in evidence against somebody because the cops needed to be bridled in some way. And the right-wingers, led by a group called the John Birch Society, tried to get rid of Earl Warren because he was interfering with the efficient conviction of alleged criminals. Well, this war went on and on and on until the 60s and intensified in the Kennedy administration. One of the big cases which they were really trying to tear down was one called Mapp versus Ohio, which said that the rights under the Fourth Amendment applied to the states. It was a search and seizure case. And we didn't really have too many cases under search and seizure until we started broadening the areas of contraband, like whiskey, things like this. So if you had items that had to have a stamp, a tax stamp, or they were considered contraband, then they were subject to seizure because they were contraband, and you needed to get them before they spoiled or got away or leaked out or whatever. And the cops, it was also kind of fun to go in with axes and bust up stills and whiskey casks and beer casks and things like this. So they didn't like to have to get warrants because sometimes product got moved and then they couldn't make arrests or confiscate the contraband or whatever. So the crimes, the possession crimes, brought about a lot of changes in the attitudes of the public, the view of crime of the public, and its response to crime. And that was the environment in which Richard Nixon was elected. And I'll have more of that in my next comment.